May I, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 14, 15, and 16 on behalf of AAG Arish Nabam. He instructed me to adjourn this matter for 2 weeks, Your Lordship.
14, 15, 16.
Yes, Your Lordship.
What about 13?
13 is.
Yeah, clubbed
Yes,
together.
13 was Lordship. After 20.
13 to 16 are
Yes,
all
Your
clubbed
Lordship.
together. Have you informed the other side?
Yeah, I've informed Your Lordship. Your Lordship, they have asked me to adjourn this list this matter on 7th of April, Your Lordship.
As straight for on behalf of Mr. Arish Navam, learned additional AG. Not objected to by the other side. These matters again on
7th of April, Your Lordship.
7th of April, 2025.
Yes, sir.
Yes.
Marvelous. And also, Your Lordship, item number 22 and 23 and 29, Your Lordship. Same, Your Lordship.
22.
23 and 29. Same order, Your Lordship.
Okay.
Yes,
Similar order. 22, 23, and 29.
Yes, Your Lordship.
Should be item 29, there is an interim order that may be.
29, you write one more line. Interim order passed earlier shall continue till the next date of listing.
Marvelous, Your Lordship.
May I, Lordship?
Yes.
Lordship, I beg to mention item number 17. On behalf of TTABAG, Standing Council of IOC, we have taken consent from order 40.
Yes, what do you want?
Lordship, after 4 weeks.
Have you filed affidavit?
No, given time for filing affidavit.
As paid for on behalf of Mr. T.
Lordship, there is interim there, so
As
the interim
paid-
may be continues.
All right, as paid for on behalf of Mr. T. Tapak, Lanet, Standing Council, IOC. Appearing for the respondents. And not objected to by the other side. Matter stands adjourned for 4 weeks. The respondents to file their counter affidavit on or before the next returnable date. To stop the interim order passed earlier shall continue till the next date of listing. Yes.
Lordship, I beg to mention item number 20 and 36.
Hmm.
The leading counsel is out of station. And this matter may be list after 2 weeks.
Who is the leading counsel?
C. Modi, Sopak Modi.
Okay, Mr. C. Modi, learned counsel for the. He's there in item 26 also. Name is not there.
No. Only 20 and 36.
36.
Hmm.
Item 20, please, right? Learned counsel, Mr. Modi, C. Modi is said to be out of station. On a prayer made on his behalf, matter stands adjourned for
2 weeks.
2 weeks. Now, similar order in item 36. Yes. Yes.
Your Lordship, I beg to mention item number 21 on behalf of the Tagum. Matter may be listed after 3 weeks.
Why do you want adjournment? Why do you want adjournment? Any reason?
To file an affidavit.
Have you taken the consent from the other side?
Yes, Your Lordship.
On a prayer made on behalf of Mr. T. Tagum, learned counsel for the Education Department. Matter stands adjourned for 3 weeks. Respondents to file their counter affidavit on or before the next date. Yes.
Yes, well, I beg to mention item number 3, my lord.
Yes.
Here, my lord, I was supposed to file some additional affidavit, my lord. I am filing that within this week, my lord. With the consent of other side, my lord, I am bringing the listing of matter after 1 week, my lord.
Mr. L. Perme, learned counsel for the Power Department, submits that he will be filing the additional affidavit
within this week, my lord.
within the course of this week. And prays that the matter be listed again after a week. Mustafa, he submits that he has taken the consent of the other side. Mustafa, in view of above, this matter again after a week.
Obvious, my lord.
My lord, I beg to mention item number 33 and 34. This both matter is interconnected to each other. I am for the respondent on behalf of the arts owner. My leading counsel is could not able to come today due to health issue.
Who is that?
Arts owner.
Ars Sonar. Is he also appearing in item 34?
Yeah, 24. This 20, no, 24, not 24. 33 and the 34.
Who's for the
Both
other
matter
side?
is connected to each other.
I am for respondent number 4 in item number 34, Your Honor, Your Lordship.
Okay. And who's for the petitioner?
Mr. K. Tari. They've informed us that they have taken
Okay, I
consent
have
from the
consent.
petitioner also.
You're taking consent?
Yeah, I have also consent.
Okay. As paid for on behalf of Mr. R. Sonar, learned counsel for the respondent in WPC number 79 of 2022.
Matter may be released after 3 weeks.
Matter stands adjourned for 3 weeks. Yes.
Much obliged.
Obliged.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 31 and 32. Lordship, it may be released after 3 weeks, since the learned leading counsel is out of station.
In item 31, I am for the petitioner.
Item 31.
In item 31, I am for the petitioner.
What do you say?
We are
Then-
challenging the DPC and the promotion of private respondent.
Any objection? You want to adjourn?
They are supposed to file affidavit.
Rejoinder affidavit,
How much time?
3 weeks. Lordship.
Okay, that's paid for by the learned counsel for the petitioner. Further 3 weeks time is granted for filing the rejoinder affidavit. In both cases,
Yes, since
rejoinder in both the cases. Or in what case?
in
No,
item
one is
32,
32.
I cannot say. In item 31, they have not yet filed. Government have already filed affidavit. In item 32, I cannot say. I'm not a counsel.
You are the counsel in which case?
Item number 32.
32
Yes, Lordship.
for the petitioner.
Yes, Lordship.
Okay, rejoinder affidavit WPC number 633 of 2023. List again after 3 weeks.
Yes.
All right.
Deeply obliged.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 7, Your Lordship. In this matter, Your Lordship, we have received our instructions. We will be filing our affidavit, Your Lordship.
7.
Yes.
How much time?
2 weeks time, Your Lordship.
2 weeks.
3 weeks, Your Lordship.
As paid for by the United State Council, who submits that Paraguay's comments has been received. Matter stands adjourned for 3 weeks. Sublet counter affidavit be filed on or before the next date.
Another mention, Your Lordship, item number 28.
28.
Yes, Your Lordship. I'm making this mention on behalf of Mr. S. Tapin, Your Lordship. He is out of station, Your Lordship. He has instructed me to pray before this honorable court to fix this matter after 2 weeks, Your Lordship.
Have you informed the other side?
Yes, Your Lordship, with the consent of others.
Your Lordship,
Mr. Ma-
date may be fixed, my lord. 2 weeks.
Mr. S. Tapin learned counsel for the
March.
respondent land management department.
Yes, Your Lordship.
Is said to be out of
Respondent number
station.
3, Your Lordship.
3, who is respondent number 3? Land management.
No, Your Lordship, DC.
Okay, you forget the land management, you just write. Mr. S. Tapin learned counsel for the respondent. Is said to be out of station on a prayer made on his behalf and not objected to by the other side. Matter stands adjourned for
2 weeks, Your Lordship.
2 weeks. Let the matter be listed again on. Today is 25th?
Yeah.
25th.
Okay.
List the matter again on 25th of March 2025 as paid for. Yes.
Obliged.
Obliged.
Hmm.
May I please, your lordship.
This is the same case which was listed the other day.
Yes.
Why did we adjourn it?
my
Because
lord,
of an arrest.
yes.
Have you received copy?
Yesterday at 7 PM, I received the copy, that too a single copy.
What to do now? We'll issue notice at this stage.
Lordship, it's not maintainable for me.
Leaving the maintainability open.
Yes, yes.
Hmm?
Because already on this honorable court, on many occasions have already decided the case.
Hmm.
And then again, they have filed some title suit, which is pending in the court of the JMFC and CGM.
Hmm.
Now, this is the third one they are coming for. And res judicata, so many things will come into play.
My lord, this proceeding that we are challenging, as I have on the last occasion also submitted, that this is the order passed by the DC. And after the coming into effect of the Assam Arunachal Pradesh Civil Code Act, the DC does not have the power to intervene in a civil dispute, particularly when the matter is pending before a civil court. Only on that point, only on that aspect. The civil court will decide the issues between the parties. They have also filed the written statement. We are also contesting the suit. The direction in the WPC was in 2017. At that point of time, 2021 Act did not came into being. Now the 2021 came into being. Oversight or whatever, maybe my lord, that is a fault on our part also, that we have not raised this issue before the learned DC. Once the Act came into being, now the DC does not have the power to decide these issues, with all respect, my lord.
The matter was directed by the honorable court only.
Yes.
By this honorable court
But-
only to dispose of the representation, if any, pending before the deputy commissioner. Now, after 6 months, they file a representation before the deputy commissioner. Now, deputy commissioner has taken up the case and it went against them. Now, again, after that, also, they have come before this court after 3 months. After 3 months, for passing of the order by the deputy commissioner. Be that as it may, the law is always prospective, not retrospective. So any act that has come into will have to be prospective, not retrospective. The order which was challenged and order passed by the honorable court was long time back before the act come into play.
Your Honor,
Until and unless the act says that this act will be applicable retrospectively, then
Okay,
it is
what
always
about,
prospective.
what about the title suit?
Title suit is there, Lordship.
You're contesting the title suit.
Yes, yes.
What is the status of the title suit?
there in the title, so your Honor, there is an application filed by us under Order 6/17 for amending the plan. The suit is at this stage. And your Honor, the retrospective effect, I don't understand what is the context of this retrospective
So why
argument.
don't you contest that title suit instead of coming here?
Your Honor, what has
Title
happened?
suit is pending according to you.
Yes, yes, title suit is pending. Your
Civil
Honor,
Courts Act empowers only the civil courts now,
Yes.
not the deputy commissioner.
yes.
So
Your Honor,
title suit is before the deputy commissioner or before
no,
the
civil court.
So why don't you go and pursue that?
Yes, yes, Your Honor has correctly asked a very pertinent question, but Your Honor, may I submit, Your Honor? DC's, the learned deputy commissioner's order is 25/11/2023. 25/11/2023. The act came into being in 2021. There is no question of retrospective. It is always in prospective effect. DC's order is of 23. Where is the question of retrospective out here? The DC has decided the issue which otherwise the 21 Act bars him from deciding that issue. Issue of title. Already when the issue was before the DC, the civil suits were pending. We have informed the learned DC also. But even then he decides the issue. What we can do?
What about the direction passed by this court?
Direction was to appear before the learned DC. At that point of time, Your Honor, the 21 Act did not came into existence. And it is our fault also. We have not raised this issue before the learned DC. The 21 Act came into being. Now you don't have the power to decide this issue between the parties, and already there is a civil suit pending.
The Act provides that within 1 year, matters are to be decided. And within 1 year, if the DC does not decide it, then as per the second proviso of the amendment of 2022, the matter has to be transferred to the competent civil court. This is what the Act provides.
Your Honor, the DC has acted because Your Honor will kindly come to, I will show the.
See, we'll do one thing. We'll issue
Yes.
notice today as it is, and I'll record the objections on the maintainability, and we'll fix a date for hearing the maintainability.
Your Honor-
That can be done at this stage, nothing more.
Your Honor, we have an apprehension that they may evict us from the land.
You may have the apprehension, but you may file your appropriate application before the competent court. Like
But
you
the,
said,
but the learned,
you have a title suit pending.
Yeah, but the learned DC has decided the title in favor of them. That there is no question of this title and ownership.
No, eviction cannot happen overnight, you see. So we'll issue notice, we'll give a short date.
No, once the issue is decided regarding title by the DC, the issue before the London Civil Court will become futile exercise, because this order will be shown to the London Civil Judge that kindly see this title has been decided by the London DC.
That time will tell. At this stage, you have challenged the DC's order.
Yes, yeah.
So what is the fate of the order is not known as on today. We'll see. First of all,
My lord-
let's see the maintainability.
My lord, one thing I want to raise, my lord, my lord, rightly, my lord has pointed out, my lord, but my lord, during dependency, my lord, we have filed this writ petition, and we have also filed before the DC's order, there is a title suit being pending. If during the pendency of these things, my lord, we
Mr.
are,
Counsel, see, if the occasion arises, you know what to do. But at this stage, you'll just get notice. We'll give a short date. See, today is what, 11th, isn't it? Within 2 weeks' time, or within 10 days' time, Mr. Afam,
Lordship,
you take instructions and submit on the maintainability.
Lordship,
And for that, I don't think you need to get any further instructions.
no.
Whatever is available on that basis, you can have.
Yes, I'll be
Okay.
only on records.
Hmm.
No problem.
Heard, Mr.
NBP Singha, my lord.
Sorry,
NBP Singha, my lord.
NBP Singha, Learned Counsel for the petitioner, to submit that by filing this writ petition, the petitioners has challenged the order passed by the Deputy Commissioner, Capital Itanagar, dated 25/11/2023, by which the Deputy Commissioner has what case is this? What do you call it? Any case number?
Your Honor, my lord will find at page 84, number in the top DC/ICC/JUD of 2/23.
This is
Page
the case
84.
number.
In the top, my lord will find in the right hand side.
Has decided the ownership of the land in question against the petitioner and in favor of the respondent number 4.
Yes, my lord.
The rest is 4.
Yes.
Stop. The Learned Counsel submits that after the coming into force of the Arunachal Pradesh Civil Codes Act 2021, the Deputy Commissioner is not empowered to decide civil cases. Stop. Therefore, the same being without jurisdiction, the impugn order should be set aside. Mr. A. Apang, learned senior counsel, appearing for respondent number 4, at the outset submits that the writ petition is not maintainable. Since raises objection on the maintainability of the writ petition. Stop. Having regard to the objection so made, it is deemed appropriate that the maintainability of the writ petition should be addressed before entering into the merits of the case. Stop, in view of above, issue notice making it returnable by 18th of March 2025. Who appears? Miss so-and-so, learned senior government advocate, accepts notice on behalf of respondent numbers 1, 2, and 3. Well, oh, okay, Miss so-and-so, learned government advocate, senior government advocate, accepts notice on behalf of respondent number 3. While Mr. D. Kamduk, learned counsel, accepts standing counsel, land management department, accepts notice on behalf of respondent numbers 1 and 2. Ms. D, Mr. Anyone with you, Mr. Apang?
Lordship?
Anyone with you? Any junior with you?
Yes. K lawyer.
Ms. K. Lawyer, learned counsel, accepts notice on behalf of respondent number 4. Since parties are represented today, notice is complete. Petitioners will serve requisite extra copies of the writ petition to the learned counsels appearing today. List the matter again on so-and-so.
My lord, I am seeking a liberty to file some additional affidavit
Oh,
for bringing on certain documents, my lord. We have not enclosed all the documents. We'll serve a copy to them also before filing.
okay. Liberty is also granted to the petitioner to serve to file an additional affidavit to incorporate documents which, according to the petitioner, has been left out.
Then Lordship, longer time may be given, Lordship. Otherwise, you would furnish a copy just before court hour.
My lord, he has to also bring instruction and give us that copy of
When
instruction.
can you file the additional affidavit?
We'll file as soon as possible.
Let the additional affidavit be filed on or before 18th of March 2025. Then in the beginning part, you write returnable by 20th, 20 instead of 18. No? List the matter again on 20th of March, 20.
Oblige.
All right.
May I appear, Your Lordship?
Yes.
My Lordship, petitioner before Your Lordship is a registered organization. They are basically imparting education to the poor students. They have opened an school, my lord, in the year 2022 by taking a temporary permission from the Deputy Commissioner. That is page 50.
15.
Yes, my lord, 50.
Oh, 50.
Yes.
50. Okay.
This is person initial Deputy Commissioner, who is the ex-official chairman of the area. This is a private school, my lord. At present, total enrollment is 402. Out of which 25% is BPL students, my lord. We are providing free of cost education to them.
BPL.
Yes, party line. My lord, second paragraph, my lord. Therefore, auxilium is called Kurung Pathar. Bodomsa is allotted to run temporarily for 1 year with effect on the date of issue of this the permission. And before that, my lord, that before granting this permission, Deputy Commissioner sought and report also, my lord, whether the school has infrastructure, whether there is a facility or not. My lord, physical report is there in page 48 and exercise 6. In exercise 6, my lord. This is the board report. It is headed by ADC, being the chairman. of the committee. And also, my lord, Vice Principal of Government High Secondary School, Bodumsa, the BRC Bodumsa, and Junior Engineer Power, they are the committee member, my lord. They have said it is fit for run the school. Every facility is there. The smart class, my lord, everything is there, my lord. This experiment observed and found during our physical inspection, associate Exilium Missionary Private School, Kurum Patar had fulfilled all the physical requirement from an ideal residential school. This is residential cum boarding school, my lord. Since the physical requirement of the building structure and other necessity provision has already been there, therefore board members recommended for issuing them necessary permission for establishing a residential cum day school after obtaining other documents in course of time. In person to this report, the Deputy Commissioner granted the permission. Then in the permission also, my lord, we have been directed to you apply for permission or apply for recognition from the DDE, Director of Elementary Education, my lord. That our application is pending, is still pending. This is my application, my lord, is page 51. In a requisite form, we have applied for
Application for what?
application for recognition.
Recognition.
Yes. This is forwarded by the Deputy Commissioner. All information has been furnished. Everything, number of students, my lord, number of teachers and their qualification. Everything is there, my lord. They are highly qualified teachers. They are MA with BS, my lord.
What is the, how many classes are there? In this
Up to class 7, man.
From one
From UKG to from
UKG to 7.
7. There are 402 students in total. Out of that, 25% is BPL student. We are giving free of cost.
25%.
Yes, my lord. 25%. That was countersigned by the ADC also, my lord. There is no dispute to that fact.
Okay.
Yes, my lord. Then
So-
the forwarding report is page 64.
What happened to your application for recognition?
Is pending, my lord. Kindly see, forwarding report is page.
When was it submitted?
It was submitted, my lord, 2/7/2024. Page 51, date is there, my lord. And
Yes.
Director Office received on 22/7/2024. This page 64. Can you see, my lord, page 64?
Yes.
This is the forwarding by Deputy Commissioner, Sanglang District. Inviting your reference to above, I am forwarding here with the application along with Form 1 and Form 1C submitted by the manager, Exilium School, Kurumpatha, Bodumsa, for recognition of this school. And in the bottom, my lord,
See,
receipt.
page 51.
Yes, page 51 is the application, my lord.
No, page 51, this application was submitted to the director,
Yes, my lord.
not to the
But
DC.
you have to be rotated from the Deputy Commissioner, my lord. This is the forwarding report only, my lord.
So you should have written here through the deputy commissioner.
No, my lord, what happened, every application has to be routed for the recommendation of the DC is required, my lord.
I understand. That
Yes,
is
sir.
why you should address this to the director of elementary education.
No, Director of Elementary Education, my lord.
Listen, Mr. Counsel. So you have to address to director of elementary education through the deputy commissioner.
That
you have not written.
That is not.
So that's why I was
But-
wondering why you have written to
Yeah,
the director.
Yes,
Again, DC again has written to the director. So what you say is that you have routed to the DC.
yes,
You have, yes, to the DC. You submitted to the DC has sent it to the director.
yes.
So this letter,
Then-
17 July,
Yes, my lord,
forwarding,
forwarding.
then what happened?
Then, my lord, the Deputy Commissioner issued a circular. This page 65. That is
Yes.
also reflect in the interim order. Kindly see page 65. Date is, my lord, 13/8/2024.
Yes.
This is a circular, my lord. That may I read, my lord? It is a general information to all the society, trust, agency, organization running unrecognized private school in Sanglang districts are invited towards the provision of Section 18 of Right to Education Act 2009, which say that no school shall, after commandments of this act, shall establish, function without obtaining certificate of recognition. Society trusts organizations running unrecognized institutions are asked to register themselves with the education department as per so and so manner. According, and it is third paragraph, it was brought to the notice that all concerned running unrecognized private schools shall attract penal action under Section 18(5) of the Right to Education Act 2009, which may include fine up to 1 lakh in case of continuing contravention to a fine of 10,000 rupees for each day during which the contravention continues. Total number of private schools in Sanglang districts are 79, out of which 49 is recognized, 30 unrecognized. In spite of ample time given to this private unrecognized school, flowing 30 school are there, my lord. Our name is in second page 66. Name of the block is Bodumsa. This is serial number 5. This is written as unrecognized Bodumsa. In this circular itself, my lord, in the last paragraph, page 67. Therefore, running a private institution without government recognition and prior approval from the competent authority is illegal, gross violation of Section 18 in Arunachal Pradesh Education Act 2010. Therefore, all recognized schools are hereby directed to submit all required documents within 45 days. So accordingly, my lord, we have approached the Deputy Commissioner, and Deputy Commissioner issued a no objection certificate. My lord, kindly see page 68. Page 68, man. This is to certify that Chairman Auxilium School running of Kumung Patha Bodumsa Sanglang district has applied for NOC in the name of Auxilium School Sanglang and submitted all required documents, my lord. Pursuant to this circular 13(8), we have submitted all required documents for opening a private school as per DE Itanagar Government of Arunachal guideline. That is Director of Elementary Education. There is a guideline. The opening of private school in Kurung Pathar, Bodumsa is very necessary for quality of education of the children of the area because there is no private school functioning in Kumung Pathar, Bodumsa area. Existing government school is not able to adjust the students of nursery KG above due to crowded population and shortage of teachers. Therefore, there is no objection from district administration for opening private school in Kumung Pathar, Bodumsa, and recommended for grant recognition of Auxilium School Bodumsa, Sanglang district. This is then thereafter, my lord, the same sort of circular was issued by ADC.
Okay, just a minute before we proceed further. This page 68.
Yes, my lord.
This is written by the Deputy Commissioner.
Yes.
On the top of this page, what is this? Office of the Deputy Director of School Education.
But office of the, it is under the control of my lord, Deputy Commissioner. But
no, Deputy Commissioner is also.
Yes, my lord, impugn order is also issued like that, my lord. Can you see?
No, Deputy Commissioner is also functioning as Deputy Director.
Yes, my lord.
Of School Education.
School Education. Chairman of the district, man. Overall in charge of the district. Then, my lord, page 69. There is 3 March 2025. On that day, we have been asked to submit the documents on 6 March 2025. Second line, our name is serial number 5, serial number 4. Last line, my lord. They are requested to produce all requisite documents for running private school scheduled on 6 March 2025 25 in ADC conference hall. We have personally appeared and our document has already been countersigned by the ADC. Then, my lord, surprisingly, on the same day, on 6 March, on 6 March, my lord, interim order was issued. Referring to my lord, circular dated 13/8/2024, this Annexure 10. Now, interim order is Annexure 13. May I read, my lord?
Yes.
Reference number so and so, running of private and running of unrecognized school in Sanglang. Whereas total number of private schools functioning in Sanglang district are 72, out of which 53 private school is recognized and 19 school are unrecognized. Whereas in spite of ample time given to this private school to submit all required documents for grant of recognition, but they failed. Whereas 19 Therefore, 19 unrecognized private schools of Sanglang district are directed to close down their school with effect from the date of issue of this order. Our name is, my lord, 11, serial number 11. Whereas running a private school without government recognition order, prior approval from the competent authority illegal and gross violation of Section 18 of Right to Education Act and Arunachal Pradesh Education Act 2010. Then next paragraph. Whereas unrecognized school mentioned above are hereby directed to close down the school with effect from the date of issue of this order and hereby directed all unrecognized school of Sanglang district not to take admission from the session 2005-2006 unless they have successfully obtained registration from the director, Elementary Education Government of Arunachal Pradesh.
Okay, what is the procedure for making the registration?
My lord, there is a process to obtain permission. Initially, we took a permission from the Deputy Commissioner, he being the chairman of the district and competent authority. As per the Act, my lord, the director has to grant recognition certificate. We have applied in form as per schedule, my lord, forms 1 and 1C. We have to give the particulars of teachers, students, and inventories, everything, my lord. If we do not fulfill, then we may not grant recognition.
Who will grant you the?
And the director of elementary education, because it is a primary school. It is up to only class 8.
So your application has been forwarded by the Deputy Commissioner?
Yes, my lord.
Director?
That fact has been ignored and appeared time and again.
And the Deputy Commissioner has given no objection?
No objection also, my lord.
And the same Deputy Commissioner has issued the impugned order?
That's why, my lord, ignoring to the fact that we have already applied and we have submitted all the documents. On 3rd March, there is a notice issued, circular issued by the ADC to appear before them on 6 March. On the 6th March itself, we appeared. Our document, all document has been countersigned. And without the ADC office is, my lord, at Bodumsa, the impugned order was issued from the district headquarters at Sanglang. Just, my lord, 1 day journey. No, yes, my lord, without hearing us, my lord.
Chutago, anything?
My lord, the first thing, how this school, my lord, has been allowed to function, my lord. First of priority is this function established, my lord. It has to be registered with the authority, my lord, as per Education Act, my lord. But it seems that at page 50, my lord, temporary permission has been granted by the Deputy Commissioner, my lord. In fact, before the school is commenced, this should have been registered with a Director of Elementary Education as per Act.
No, that process was being carried out.
My lord, this is, my lord, that it will take time, my lord. It seems that page 51, my lord, the application was only submitted on 2nd July 2024, my lord.
Yes.
So the DRS details the exercise has to be carried out to ensure that this school is meet up with all the requirement. So this exercise, malab, the up to date latest position, malab, I have to take instruction, malab, this. What is this task, malab? But as per my understanding, malab, the first it should have been recognition. The school has to be first registered in the with the authority, the competent authority, as per the Act, Right to Education Act, as well as Arunachal Pradesh Education Act. It says that this act says that no person or authority shall run the school without it is first registered. It appears that this is not registered. That's why, my lord, the commissioner, having granted temporary permission, having and the letter realized that this has not been registered. Maybe that's the reason that's impugn order.
What the circular says is certificate of recognition, as per section 18 of the Right to Education Act.
Yes, my lord. Section 18, my lord, it says, my lord.
Yes.
Section 18 says, my lord, no school shall establish without obtaining certificate of recognition. Same as it is in the Education Act, my lord. No school can be run without.
Correct. That is why they have asked for this recognition.
Yes, my lord.
And
So this
petitioner has also applied for it.
Yeah, that is why, my lord.
And it has been forwarded to the director.
Yes.
Now, the deputy commissioner also has given no objection certificate.
That's
because they say that there is requirement of the school.
Now,
while the application is pending, then why this impugn order?
My lord, that part, my lord, the our part, so for education department, director of elementary education, my lord, I've sought instruction as to the status of the application, my lord. Yet I have to receive this, my lord. Regarding, my lord, impugn order has been done by the deputy commissioner at district level, my lord. So for this application, whether this school can be granted recognition or not, my lord, the government is considering, my lord. To that aspect, what is the status, my lord? I've sought for, my lord, telephonically, my lord. I could not gather the information.
When can you get the status? When can you get the status?
My lord, just I requested them, my lord. Maybe they are trying, my lord.
Now, exam is also going to be held from, my lord, 13 from tomorrow.
Okay. Exams
of the school.
No. That part, okay.
Where have you stated that?
This page 75.
Huh?
Page 75. Last page. This is the schedule of
75?
Yes, my lord.
It's not in your read petition.
Yes, read petition.
No, you have not made a statement to that effect.
Oh, there is, my lord. Yes, I have made a categorical statement. Yes, Chairman. Paragraph number 12. It is basically stated presently school has an enrollment of 402 students of class from KG up to class 7 standard, out of which total enrollment 25% from backward class. Petition society is providing free education to them. Annual examination of the school is scheduled to be held with effect from 13/3 to 28/3/2025. Well, it is not the case that we have not applied. We have regularly keep in touch with the district administration. And the school has well furnished, my lord. That is the first school in the area. It is a vast area, my lord. "14 hectares land."
All right, we'll issue notice.
Yes, my lord. In the meantime, my lord, this order may be stable.
Heard, Mr.
S.K. Deori.
S.K. Deori, learned counsel for the petitioner, who submits that the petitioner is a registered society, registered under the Societies Registration Act, and running a school under the name Auxilium School, Kumung Pathar, Bordumsa in the district of Changlang. Stop. He supposes that there are as many as 402 students, out of which 25% of the students are below the poverty line and are not charged any fees. To stop, the school has the classes in the school are from UKG to class 7. To stop. After a physical verification report was submitted, by the constituted members regarding the feasibility of having an ideal residential school, a temporary permission was granted by the Deputy Commissioner, Changlang District, to run the state school for a period of 1 year with effect from 23/3/2023. Stop. The school managing committee also applied for recognition of the school by submitting an application to the Director of Elementary Education through the Deputy Commissioner, Changlang District, on 2/7/2024, while annexing all the relevant documents required for being recognized. Stop. The application was forwarded to the Director of Elementary Education by the Deputy Commissioner on 17/7/2024. Stop. In the meantime, a circular was issued by the Deputy Commissioner providing that all the private institutions without government recognition should obtain prior approval of the competent authority as mandated under Section 18 of the Right to Education Act 2009. Stop. The petitioner, in the meantime, had already submitted application for recognition, and the Deputy Commissioner had also issued a no objection certificate on 7/11/2024. In favor of the petitioner school. Stop. However, by the impugn order dated 6/3/2025, as many as 19 schools, including the petitioner school, have been directed to be closed down with effect from the date of issuance of the order. So the Learned Council submits that since the application for recognition had already been submitted with the recommendation of the Deputy Commissioner, Changlang District. The impugn order dated 6/3/2025 has caused great prejudice to the petitioner. And therefore, the same should be set aside insofar as the petitioner is concerned. The Learned Counsel also submits that the examination in the school is scheduled to be held with effect from 13 March 2025 to 28 March 2025. And therefore, unless a protection is given to the petitioner, the children of the school admitted in the school will suffer irreparable loss. Next para, in view of above, issue notice of motion returnable by 3 weeks. Mr. T. Tagum, Learned Standing Council Education Department, accepts notice on behalf of respondent numbers
1, 2, and 5.
1, 2, and 5. Then Miss So and so, Learned Senior Government Advocate, accepts notice on behalf of respondents 3 and 4. Since parties are represented, no formal notice. Respondents are represented, no formal notice is required. Petitioner shall serve requisite copies of the writ petition to the learned counsels appearing today. Next para, having regard to the projection made, it is provided in the interim that the order dated 6/3/2025, insofar as the petitioner is concerned, shall remain stay till the next date of listing. List the matter again after 3 weeks.
Yes, my lord, DPO. May I plead your lordship?
Yes.
Yeah. Well, this matter relates us to PMGSY road.
Yeah.
So basically what happened is that project is that's called Nampe Sario project. It is around 40 kilometer PMGSY project. And the petitioner's lens comes under this, between this Nampe and Sario. So what happened is that without acquiring, without paying compensation, they have entered in the lane of the petitioners' villages. And then they have destroyed many gardens and farmlands, trees of the community land. So, but then they have not paid compensation. They're saying that under PMGSY project, there is no compensation components. But then as per the PMGSY guideline, it says that while preparing the project, they should have a land certificate, or they should have a land donation, or maybe they should have agreed with the Gram Sabha. But this was not the case in this project. They, being the project, they started constructing the road in the villages, especially the petitioners' villages. When they sought for the compensation, then they are saying that this is a PMGSY project, so we are not bound to pay the compensation. So they have written series of corresponding to Deputy Commissioner, the acquiring authority, but then they are still not ready because this is the illegal position, because it is without acquiring, without getting donation. If they are entering in the land of the petitioners or villages, it is amount to a disposition. It's an amount to illegal and it's an encroachment and illegal disposition. Now they have already, out of 40 kilometers, they have already constructed 24 kilometers since 2017. But they have started late the construction. Till now, till the June 2024, as per the status report, said that they have completed 24 kilometer complete, and they are yet to complete around 16 kilometer. And this is all being done illegally, without the confidence of the landowners. But whereas the guidelines say that even if there is no project, what you call compensation component is there from the central government, but then state can acquire with its own cost. This is as per the guidelines. we have not enclosed in our guidelines, but then as per their counter affidavit filed by Deputy Commissioner and Secretary, they said that it is as per that guideline, it says that land can be acquired by the state with its own cost. Now, in their reply, it says that some money has been given to the society, whereas society, we don't know who is the society. Maybe there's some society, maybe they have paid to some groups, but then villagers out of it, there's around 300 populations. Out of that, seems to be, they are saying that they have did agreement with the contractors and the villagers. They have paid around 93 lakhs and is paid to the society, and the society has taken responsible to give the lane, to take the lane for the acquisition. That is how the Deputy Commissioner and the Secretary is in their affidavits. So this is the case in our writ petition. So I will just take to the relevant projects, relevance. This one annexures.
Who is the respondent numbers 1, 2, 3, and 9?
Respondent number, yes. Let's take 9 is a private contractor. And then respondent number
1, 2, 3. Land management. Land management.
Land department, yes. We have made land department.
You have not responded to the writ petition. No counter affidavit.
No, my
Lordship, I have filed, Deputy Commissioner.
No, that we have seen. 6, 7, and 8.
6, 7, 8.
6, okay, 6, 7, 8 is the what? RWD.
Yes.
Yes, 6, 7 is the RW.
Then Deputy Commissioner has also filed.
Yes, Lordship. I have filed.
Respondent number
Lordship,
Respondent number
4
4.
and 5. 4.
4 and 5, yes. 4 and 5 is the Deputy
When did you
Commissioner,
file?
additional Deputy Commissioner.
Yes, 4 and 5 is right.
Respondent number 9, I think they're not ready to file affidavits. I think this last occasion they said that they are not ready. They will not file the counter affidavits.
You are the contractor who's constructing the road. Okay, then this land management has nothing to say in this.
Give me some time.
See, this is not a isolated case. I think there are other cases also wherein this PMGSY scheme has been implemented.
Yes.
And people are coming saying that we are not being compensated. And the respondents are saying that there is no component for compensation. And yet they say that when the scheme was to be received from the central government, then they show documents saying that they have got possession of land.
Normally, in all the projects, villagers, it is not the case that without donation we have executed.
But yet there are parties are coming before the court that they are not being compensated.
But in some cases, the villager within the villagers, there become two groups. So those group who could not get the work, they will come before the court. This is the most of the case prevailing.
No, that is, I think I may not
Here
agree
in
on
this
that.
case
Because
also, the
it's a
contractor is a member of their clan only, the petitioner's clan. And we are told that out of contractor has paid some payment to the clan members, to the society. The society have they taken the responsibility that we will let the road construct.
Yeah, this is the
Without any disturbances.
Who is the society?
exactly.
That is Lamnio Welfare Society, which the petitioner is one of the members.
Society is not, my lord, it's not registered, and then villagers even don't know that society which they are saying, your lordship.
Even it is not registered, every clan, every society have their own organizations. So
But they cannot represent the community lane and
He
individual
knows.
land. That is the
and inter land, almost the land is belongs to community. But within a community land, individual can have a guardians. That is not disputed. Here in this case, the society, whose the petitioner is also members, that society have decided, because the contract tender was also got by the members of that society, so they have sitting, and then decided we'll let the work executed as per the DPR, as per the alignments. So there should be no disturbance. If there is any land dispute, we will take care of that. They have undertaken. And as per the affidavit of the Deputy Commissioner, the contractors has paid some money to the society. Normally what happens, my lords, if a road is passed through some individual's land, it can be compensated by the contractors who execute the work by giving a culverts, giving some works. In that way, otherwise more than 15,000 kilometer road are being executed under PMGSY roads. There are more than thousands projects. If the state started giving them a compensation, it will open a Pandora box, and the state which they depend on the central government. In the PMGSY, central government said we will not give any pound for the land compensation. So it is up to the state government. So state government, they involve the Panchayat Raj, the village peoples, for land donation. No accusation is done. Only on the basis of land donation. Even alignment is also shown by the villagers themselves. On the basis of that, we prepare a DPR and proposal is.
Despite such kind of understanding, but yet there are still some claims from some other corner.
Of course, my lord, there is there, but once it is started, then the state will be facing so many problems. It will be very difficult to compensate all the projects.
I think it is such a big community. Okay, villagers need villages. We agree to that. But at least when they are doing some, they have garden, they have some properties. At least that should be assessed by the authorities. Maybe central government doesn't have fund, but then state, there is even in guideline also says that the state government can acquire on its own cost. So now question is, in this case, they have given a free, authority will give free hand to the contractors. Contractor will do whatever he likes. So here in this case also, he catch hold of some of the society. Society consists of around maybe 91 members, I think. So the compensation which they have paid around 93 lakhs, it is being distributed among the 91 beneficiaries, maybe, I don't know. So there is around 300 members in this village. And then majority of the villagers, I don't know where the compensation and how they pay, but then they will just come and bulldoze whole of the areas. I mean, that it cannot be done by the authorities and by contractors. When the lane is a constitutional right, and if it has to be taken away, then it has to be taken away as per the procedural law. Maybe the LARA is not applied, but then the state can have own mechanism to acquire the land. But this is not the case here. They will alienate the land of the villagers. I mean, they're not saying that we don't need a road, but then road we need, but then at least minimum the property which has been damaged, that also should be compensated.
All right. Has any case been decided in this regard? There are a few cases, I guess, pending. We had noticed the other day also there was another case of similar nature.
There are some. In some cases, they used to withdraw after some time.
But whether this is whether the
in this case, I think perhaps land management would like to say something, or we say that you have nothing to say.
Yesterday also my lord has dealt with PIL matter. Also involved issue matter. That was also regarding the PMGSY.
In this case, are you going to say anything?
My lord, since some cases of this kind is coming up, my lord. Government has to make this is still clear, man. So I feel like my lord here we need to file a petition. Otherwise, my lord, since there are so many similar cases, my lord.
All right, we'll give you some time then.
My lord, please.
Then
My lord, otherwise I was,
You were
I would
ready.
press that it can be disposed of.
No, let us give them one more chance, land management, see, because
Yes,
this is not a isolated case. There are other matters.
Other
as
matter
well.
also,
So,
Since my learned friends, my lord, they have already made a submission that there is no provision for compensation in this PMGSY. Next matter.
but that will not bar, my lord. Because as me as a landowner, I have a constitutional right under Article 300A. So they cannot take away my land.
They are the real landowner, my lord.
So this is matter, it is a matter of the deputy commissioner to verify, my lord.
see, Mr. Kamdu, you argue once you get the instructions. If you say that you're not going to file affidavit, we'll record that and we'll
Yes.
take up the matter for
Yes.
admission.
Lordship, here, before the construction started, they made a deed of agreement between the parties. And here itself, they have,
No, you wait for your turn. At this stage, we'll just give some time to the land management department
yes.
to file whatever they want to.
Yes, madam.
If they file, well and good. If they don't file, then we take the matter. Then you can make your submissions.
Lordship,
Please write down, the grievance of the petitioner while filing this writ petition is that they have not been given any compensation despite the fact that road has been constructed by affecting their respective land under the PMGSY scheme. Stop. It is the case of the respondents, on the other hand, that there is no component for paying compensation under the PMGSY scheme, and it is on the basis of mutual understanding that such work has been carried out. Stop. All the respondents except the land management department and the contractor executing the work, bracket respondent number 9, has not filed their counter affidavit. Stop. Mr. D. Kamduk, Learned Standing Counsel, Land Management Department, submits that he may be given 3 weeks time to obtain instructions and to file counter affidavit. Stop. Considering the prayer made, further 3 weeks time is granted to the respondent land management department to file their counter affidavit. List the matter again after 3 weeks. All right.
No, like.
Yes.
The petitioner said, why we rejoined
Why?
They have filed the rejoin along with the new documents.
So this will not be a reply. I think it will be an additional counter affidavit.
Yes, my lord, they have filed counter affidavit, my lord, to
No.
our this.
They have filed counter affidavit.
Yes, my lord.
You have filed your rejoinder.
Yes, my lord.
Now they want to counter that again.
Yes, again, they want to counter my this region.
How long will it go on like that?
They come up with the new documents.
Oh, show me what is the new documents.
They have submitted the application to the sub-register.
Normally, after rejoinder affidavit, matter stops. Only in exceptional cases, we may allow you to file additional counter affidavit. Show us the document which says that, which according to you is new in the rejoinder.
Between their rejoinder, it's not rejoinder, page number 36. This is the new document. This document was never part of the petition of the other.
36. What is this? Application for cancellation.
Yes. My television.
Okay, how much time? Counsel for the respondent by referring to annexure A-1 of the rejoinder affidavit filed by the writ petitioner submits that the same was never part of the writ petition and therefore court may grant permission to file additional counter affidavit. Considering the prayer made, 2 weeks' time is granted for filing additional counter affidavit as paid for. List again after 2 weeks.
Obliged, please.
Number 6.
My lord, this is writ petition is seeking payment of this admitted outstanding bill, my lord.
House rent,
Outstanding bill, my lord.
outstanding bill
Yes,
for
my
what?
lord. For execution of my lord, Saubhagya work, my lord, at rowing, my lord.
What work?
Saubhagya, my lord.
Saubhagya?
Yes, my lord.
Construction of building?
This is, my lord, for rural electrification, my lord. Executed by for this power department, my lord.
Electrification.
Yes, my lord.
So what are the documents which says that it is an admitted liability?
Yes, my lord may kindly take up my rejoinder, my lord. Before that, my lord, I will just highlight the fact, my lord, leading to filing of this writ petition, my lord. There is no dispute, my lord, it was called for. The petitioner was awarded the work. He had executed the work, my lord. After execution, successful execution of the work, my lord, there was this material inspection by the department, and thereafter, my lord, completion report, this certificate was issued to me, my
No,
lord.
execution of which work?
Yeah. Now, my lord, before my lord taking up my this rejoinder, my lord may kindly take up the affidavit filed by the respondent, my lord. Department.
No, let us see your writ petition file.
My lord.
What, on what basis, on what strength have you filed this? Annexure 1 is letter of acceptance
Yes, my lord.
in favor of the petitioner
Yes, in favor of the petitioner, my lord.
issued by the
Issued by the executive engineer, electrical division, my lord, rowing electrical division, my lord. So thereafter, my lord.
So your claim for the the amount is on the basis of this document?
Yes, my lord.
Your tendered amount was 4 crore 39 lakhs. This
Yes,
one?
my lord. Yes, my lord. 4 crore 39 lakhs. From that, my lord, I have been partly paid, my lord. That is admitted, my lord. Only now.
You have been partly paid.
My lord. Yes, my lord.
Partly paid.
Yes, my lord. The remaining, my lord, amount is, my lord, 1 crore 27 lakhs 87,689 only, my lord.
This is the balance amount?
Yes, my lord. My lord.
From these 4 crores?
Yes, my lord. Yes, my lord. My lord, page number 19, my lord. These are the, my lord, articles, materials which I was to be, I was to supply, my lord, to the department, my lord. Schedule of quantity and rates, my lord. Article. Page 19.
Just a minute. Which one?
Page number 19, my lord, this is the, my lord, quantity and the rates of the materials, my lord, that the contractor was supposed to supply, my lord. My lord, may kindly note, my lord, serial number 6. These are important, my lord. Page number 19, my lord, serial number 6, my lord. And serial number 6.
Guard bracket.
Yes, my
with
lord.
Clamps, this one?
MS guard bracket 3.5 mm. So my lord.
With clamps, nuts and bolts. Yes.
And item number 16 is also important, my lord.
copper strip size, so and so. Then, my lord, turn to kindly next page, my lord, page number 20. Item number 21 and 22, my lord.
These have been supplied.
My lord, these are the items, my lord. They are saying that I have not supplied totally, my lord, but I'll, my lord, convince this honorable court, my lord. I have supplied entire material, my lord, but they are trying to, my lord, deny that I have made the full supply, my lord. And my lord, these, as my lord has seen, these were the items, my lord, the contractor had to supply to the department, my lord. Thereafter, my lord, page number 21 is the agreement for execution of the work.
Page number
21, my lord, and lecture 2. After the letter of acceptance, my lord, this agreement was drawn, my lord. It was drawn on 31st October 2018.
The amount has been mentioned here.
This, my lord.
Amount is mentioned.
Amount, my lord. No, my lord. This work order is mentioned, my lord.
Why amount is not mentioned?
Amount, my lord. There is some other document from where we can gather the amount, my lord. That amount is not disputed, my lord. Total amount, the gross amount, my lord. It is
Now,
not
where is
disputed.
the reference
To
to the letter of acceptance? Okay.
Yes, my lord.
What paragraph? Letter of acceptance.
Yes, my lord. Yes, past in letter of acceptance, my lord, it is given, my lord. 4 crore 39 lakhs 60,204, my lord. Next, my lord, the important document is page number 28, my lord. 28.
Page 28.
28, my lord. This is field inspection report, my lord.
Yes.
This is to certify that the inspection of the installation of electrical infrastructure under the scheme households electrification in Lower Dibang Valley district under Pradhan Mantri Sahaj Bijli Har Ghar Yojana. Saubhagya has been carried out successfully as per details enclosed as Annexure A, my lord. Now, this is the field inspection report. Thereafter, my lord, another important document is page number 29, my lord. This is completion certificate, my lord, issued by executive engineer, Rowing Electrical Division, my lord. Yes, my lord.
What is the nature of work? For supplying or for installation?
It is supply of this material, my lord. For installation of this my lord, infrastructure, my lord. It is for supply of the material, my lord.
You will only supply, not
Yeah,
install.
already supply, my lord.
Who will install?
Even the department, my lord.
Department will install.
Yes, my lord. After
you are only supplying the materials.
Yes, my lord. So, my lord, here even, my lord, if the supply was not completed, my lord, it was not fully performed, my lord, installation could not have been, my lord, done, my lord. But in this case, my lord, even the installation part is complete, my lord. Without any supply, it could not have been, my lord.
Okay, so
now this is work done completion certificate, my lord. Now, my lord, my claim next page, my lord. Page number 30, my lord.
Yes, page 30.
Page 30, my lord. This was second column, middle column, my lord. Outstanding bill, my lord. Here, my lord, the right side net amount, my lord, it is 1 crore 27 lakh. This is what, my lord, I am to be paid yet, my lord, by the department, my lord.
This is the outstanding amount.
Yes, my lord.
Okay. Who has prepared this?
This is prepared by executive engineer, my lord. Kindly see the bottom, my lord.
How much have you been paid?
My lord, I have been paid, my lord, that is in my this repetition, my lord, I will come to that later.
No, no, it is not available in this
Yeah,
document.
It is available, my lord.
Which is the one?
My lord,
Payment till date.
yes, next page, next.
No, no, same page.
Page number 32, my lord.
Not 32. What about in page 30? Is it not
30.
available there?
30.
The first column says payment till date. Second column
Yes,
says
yes, my lord. The
outstanding.
first column is the one, my lord, which I have received, my lord.
Gross
The
amount is
yes.
much.
The gross amount is, my lord, 2 crore 72 lakh 80,000, 82,000. Sorry, no, my lord, this is 2 crore 72 lakhs 3,000.
No, no.
860.
The gross amount is at the bottom, total.
Yes, my lord.
4 crores 39 lakhs.
Yes, ma'am.
This is the one.
This is the one, my lord.
Then what is this? I tax, then
This
excess.
tax, my lord, I do not have idea, my lord. GST is the SS is this I tax, income tax, it must be income tax, my lord.
Income tax. So after deduction of all these tax and cess and all that, the amount comes to 4 crores 22 lakhs.
Yes, my lord. Out of that, my lord, what the petitioner is entitled and has not been paid is, my lord.
So far, you have been paid at the top payment till date. Serial number 1 and 2.
Yes, my lord.
1 crore plus 96 lakhs.
Yes, my lord.
Total comes to how much?
Total comes, my lord. Last one. I have not worked out, my lord, but since
you know only how much is to be paid to you. You don't know how much is already paid to you.
yeah, my lord, that is the only issue, my lord, because they are not, we are not disputing that, my lord, how much I have received till date, my lord. That is not disputed by the parties, my lord. And only the thing is that, my lord, 1 crore 27 lakhs, it is due to me, my lord. But why or they are trying to say that, my lord, I have not made the full supply, my lord. That is only the issue. This, my lord, remaining amount, my lord.
So how do we
This
resolve that? How do we resolve such kind of a dispute in a writ petition?
Now, my lord,
you said you've given full supply. They say that you're not given full supply.
That, my lord, from their own document, my lord, I'll satisfy your worship, my lord.
From their own documents?
Yes, my lord.
You will show that you have given full supply?
Yes, my lord.
How is that possible?
My lord, they have, my lord, before that, my lord, kindly come to take up their affidavit, my lord.
Mr. Ratan,
Yes, madam.
can we simplify this matter?
My lord, we have.
Are you saying that you don't owe them, you don't owe him any more money?
Yes.
Or you're saying that there's still some amount pending?
No, my lord. We are saying that he has not supplied the remaining 30% of materials, so we cannot pay him. What he is claiming is that for those materials which he has never supplied.
Okay, even then, can we not say that, okay, let somebody verify that and find out?
For that, that's why this, by way of a writ petition, it is not.
No, since he's here, so supposing we constitute or 2 or 3 members who are experts in this field and just they find out whether it's actually supplied or not. If it is supplied, the amount which has the worth of which has been supplied will be paid. If not supplied, you don't pay them anything.
My lord,
that much we can say. On the other is, how can we now appreciate?
Yes, my lord. My lord, of course, my lord. My lord,
he says supplied, he says no supplied. This will
fact,
go on and on.
In fact, my lord, Honorable Apex Court has passed an order not to make these roving inquiries, my lord.
Not to
make this roving inquiries by a writ court, my lord, where claims are disputed, and then
When there is no in case of public interest, it is another thing.
The roving inquiry, court is not doing that. We are directing the respondents themselves. That, okay, who are the officials who can do that? Name 1, 2, 3. Let them look into it within a time frame. If they find that there's nothing supplied of this sort, then matter ends there. If supplied, then you you should pay them. Because now what you have done is what Mr. Kamduk has said. I don't know if we accept that. He has identified few items, serial number 6, 16, and 21 and 22, which according to him is that has not been supplied according to the respondents.
Yes.
That is why they have denied payment of 1 crore 27 lakhs to him.
Yes.
Now, whether it's supplied or not, how do we know at this stage?
That my lord, from my rejoinder, my lord, it will be clear.
What is the
Clear.
document in the rejoinder?
The document,
Which will make it clear.
yes, yes, my lord. Documents, my lord.
Has somebody certified that we have
Yes, my
received
lord.
this material?
Executive engineer himself, my lord. The bill, my lord, may kindly take up my rejoinder, my lord. And not before that, my lord, kindly come to take up this affidavit filed by the respondent, my lord. I'll just refer page 21, my lord. Affidavit filed by respondent number 2, 3, 4, and 5. Just straight away, my lord, come to page number 29, my lord.
Affidavit filed by
Respondent number 2, 3, 4, and 5, my lord.
yes, page number
29, my lord.
29.
Yes, my lord. 29. Annexure
Yes.
H series, page 29, 29. My lord. These are order item, my lord. My lord has a mark in my repetition, my lord. These are the same item, my lord. Groundbreaker, copper plate, earthing deep, orange paint, aluminum paint, etc. My lord. These, what they are trying to say is that, my lord, I have not wholly supplied these items, my lord.
Okay, they refer to the same items.
Yes, my lord.
6, then copper plate, then
21 and 22, my lord.
deep orange paint, then aluminum paint. These 4 items
Yes, my lord.
have not been supplied.
According to them, my lord.
Yes.
According to them. Now, my lord, now let us take up my rejoinder, my lord. I have answered everything here, my lord. I'll just unless may kindly come to page number 24, my lord.
Mr. Kamduk,
Yes,
we'll take 5 minutes break and come back.
Yes, my lord.
All right?
Much obliged, my lord.
All right. Full stop. He therefore submits that there have been clearly an alternative remedy provided in the agreement itself. The instant writ petition will not be maintainable. Next para. Upon considering the submissions made by the rival parties and upon perusal of the materials available on record, it only appears that the claim of the petitioner that the amount which remains to be paid is an admitted liability. cannot be adjudicated by this court. In view of the stand taken by the respondents, and more particularly, in view of the fact that there is clearly a provision for settlement of dispute between the parties by way of an arbitration. Such being the position, the petitioner shall approach the department authorities with an application for appointment of an arbitrator in terms of the agreement dated 31/10/2018 within a period of 2 weeks.
2 weeks, matter.
3 weeks from today.
Yes.
Stop. The department authorities, upon receipt of the same, shall take necessary steps for appointment of an arbitrator in accordance with law as expeditiously as possible and at any rate within the outer limit of 2 months. 2 months from the date of receipt of the application. Next, para with the above observation and direction, the writ petition stands disposed of. Obligement.
Deeply obliged.
Yes.
Malad, the respondent number 2, Malad, represented by Advocate Roy, is appearing Malad, on online and requested me personally for Malad accommodation at 2 p.m. Malad, subject to your lordship's.
Which respondent?
S. Roy, Malad. Respondent number 2, Malad. Respondent number 2.
Executive Director.
Yes, Malad.
You are supposed to file some affidavit, Malad.
Why is it listed today? Otherwise,
Last of them.
Today is the date listing for the Malad NDPA for Malad the disposal of the matter. In fact, they are not disputing the amount. They are only saying that Malad the other party, Malad the state respondent who has Malad the issued the tender, Malad the agreement was entered into between the parties. They are saying that funds are not being released by the respondent number 2. And the respondent number 2 contention is, Malad, due to some certain technicalities, the amounts are not being released, Malad. Only because of them, Malad, I am being, Malad.
see, last court's order says that the specific stand be brought by way of an affidavit.
Affidavit,
Who's to
Malad,
file
they
the
have already
affidavit?
filed, Malad. They filed, Malad. As per my knowledge, Malad, I am informed, Malad, the affidavit is. Other is also, Malad, that has already been, Malad, raised in the Malad petition by way of affidavit, Malad.
No.
Just to clarify that aspect, Malad, at 2 p.m., Malad, if subject to Malad lordship's
No, the
convenience.
thing is that if the court had directed that the affidavit should be filed, that it has to be filed.
Yes, Malad, they have filed, Malad.
They have filed.
Yes, Malad.
Malad, I have not received, Malad.
The copy will be made available, Malad.
No, the office note says that as directed, petitioner as well as the state respondents have not filed affidavit.
From our side, Malad, the affidavit is not
So-
required, Malad. Affidavit only on the part of Malad, respondent number 2.
Correct. So
To
the
to
office
some
note says
extent, Malad.
affidavit is not yet filed. So from where you'll get a copy
Malad.
if it is not filed?
Malad, at 2 p.m., Malad, subject to, Malad. He will clarify it, Malad. He personally, Malad, requested me and I press your lordships to Malad accommodate at 2 p.m., Malad. He's appearing from our principal seat.
This is regarding what?
Non-payment of Malad, the remaining bills, Malad.
What bill? Bill for what?
Bill for Malad, the construction of work and the supply of the electricity, Malad.
And who are the parties here?
Parties, basically, represented by my friend Parme, standing counsel for the power department. And Mr. Roy is appearing on behalf of respondent number 2, who is the agency, central agency, supposed to release the funds.
And Mr. Pema is for?
Power department. Respondent number 1.
Power. You have no role in this?
Oh, 3 and 4, man.
3 and 4.
Do you have any role?
No.
Any role?
Against our affidavit, my lord, this respondent number 2 was supposed to file some affidavit, my lord, last occasion, my lord. Then what happened in this case, my lord? There is a three-party agreement, my lord, by this respondent to us and the union government, my lord. Union government was supposed to fund the money to amount to this respondent number 2, my lord, and we need to execute, my lord. We need, in terms of the three-party agreement, my lord, that work need to be executed in our supervision, my lord. That was the three-party agreement, my lord. Now, in terms of that, we have plot tender, my lord. Work was executed by them, my lord, this petitioner, my lord. Now, central government has, my lord, already released the fund to the respondent number 2, my lord. But respondent number 2 is not releasing the fund to us, my lord.
Central government is also not a party here.
Government.
Respondent,
Central government is not a party.
Not party, but they have released the fund to the respondent number 2, my lord, already, my lord. That is a matter of report, my lord. Already released them to respondent to my lord. Now,
Now, in terms of the tripartite agreement, what is to be done? Central government will release it to respondent number 2.
2, my lord.
And respondent number 2 will release it to the state power.
Power, my lord.
And from the state, it will be released to the petitioner.
Petitioner, my lord.
And why, according to them, has not been released?
I'm informed, my lord, they have already filed, my lord, the affidavit, my lord, as per the order of this Honorable Court on the last occasion. My lord, subject to the convenience, my lord, matter may be taken up at 2 p.m. my lord, so that they can clarify everything. My lord, whatsoever the reason may be, my lord, just we want, my lord, the bill, my lord, the remaining bill. Only because of the there, my lord, my lord,
apart from the remaining bill, what else can you want?
My lord, there.
Apart from that remaining bill, what else can you demand?
They are not in fact denying, my lord. Only their contention is, my lord,
that is the only reason why you filed a writ petition.
So, my lord,
no, but the court has recorded.
Yes, ma'am.
According to Mr. Roy, learned counsel though power department have stated that they have given completion certificate.
Correct.
However, there is no utilization certificate.
Correct.
And in absence of utilization certificate, payment cannot be made to the petitioner.
Yes, ma'am.
So what is wrong in that? That is how it works, isn't it?
Yes, ma'am.
You take payment, but first you give us utilization certificate.
Correct, ma'am.
So if you cannot give utilization certificate,
we have submitted all the necessary documents we have submitted, my lord.
We'll go by one.
That's why, my lord, we are supposed to give reply, my lord, from reply, my lord.
Okay.
Let's do, my lord.
All right. Have to.
It is objection.
Yes.
There was a interlocutory application for intervention, my lord. We have filed our objection in the matter. My lord, we have filed a writ petition, my lord, claiming rights under the Scheduled Tribe Forest Dwellers Act in Namdapha Reserve Forest and the adjoining areas. We are an indigenous tribe of Arunachal Pradesh, my lord, the Singpho tribe. We have been traditionally dwelling in PCL Kampu and the earlier Kampu village. The Kampu village is now even in the reserve forest. So, my lord, we had claimed the rights under the Forest Dwellers Act as a scheduled tribe. Now, the intervention application has been filed, my lord, IA 146.
By whom?
By one Yobin Welfare Society, claiming that they belong to a tribe called Yobin, and they have also been residing in the area. My lord knows that in Arunachal Pradesh, land is owned tribe-wise. Tribe-wise, a particular community owns that particular plot of land, or area of land, villages.
May I please, my lord? My lord, I have been instructed to seek time to file reply on the objection they have filed, man. by the council, my lord. We need to reply, we will file in reply, my lord. So sometime maybe. I've been instructed to seek time.
My lord, in fact, they don't have any locus because this is a welfare society. A society will not have locus, my lord, in a matter of rights under the Forest Dwellers Act. They do not claim to have filed it in the representative
No,
capacity.
what is your claim in your petition?
If my lord comes to the prayer portion, my lord.
Sorry. So much of prayers, A, B, C, D.
Basically, rights under the Forest Dwellers Act. And
what are the rights?
My lord, rights.
Compensation
as well. Because our land has been taken away. It's basically compensation and rights under the forest.
Compensation, why?
Because our land has been included in the forest, in the reserve forest.
What is the forest reserve?
My lord, Namdafa Reserve Forest in Changlang district, my lord.
I see. And the intervention applications filed by?
One Yobin Welfare Society. They do not say that they have filed it in representative capacity. So how can they claim rights, first of all? Secondly, my lord, they have not made the other parties, that is the Union of India and the state respondents, as opposite parties in this interlocutory application. It is filed only against the petitioners. On my lord, on a technical ground, that is my objection. Thirdly, my lord, Yobins are not scheduled tribes. I have annexed the scheduled tribe order. Yobins are not scheduled tribes.
What is their claim? They also say that they are affected.
They are affected.
They are the ones who are affected.
They are the ones who are affected. They claim that. But my lord, this land is traditionally a Singpho land, which is there not only here, but also in the Constituent Assembly debates. Constituent Assembly debates, even in the census. In fact, my lord, it was only in 1994 that they have been recognized as citizens of India. I've annexed that particular notification as well.
Okay.
First of all, they are
anyway, Mr. Nair, we want to clarify things by way of a reply. We give them a short date.
Could it be along with the other matter, my lord, on 7th April, my lord?
7th April?
Some other.
Okay.
The government had mentioned today morning the other.
Counsel for the applicant in the IA submits that he may be permitted to file a reply affidavit to the objections raised by the respondent. Prayers allowed. List the matter again on 17th of 7th of April. 7th of April 2025. Objections be filed. A reply be filed on or before. When can you file? 28th?
Yes, ma'am.
28th of March 2025 with a copy to the other side. You supply copy so that last minute.
Yes, ma'am.
Correct.
DP applies, ma'am.
Item number 10 and 11.
Please, my lords.
My lord, in this case, my lord, two matters are similar, my lord. In item number 10, the pleadings are complete. But in item number 11, we have to still to file the affidavit in opposition. As the item number 11 was lately filed. So I need 3 weeks time for that, my lord.
In item 11?
Yes, item 11.
10 you have filed.
10 years pleadings are complete. Initially, it was filed in the principal's bench, my lord. It was transferred to here.
You're for the respondent?
I am for respondent, my lord.
Respondent, which respondent?
My lord, 2 to 6, my lord.
Private respondents. Private respondents?
No, my lord. It's respondent number 2 to 6. It's about Central Goods and Service Tax, my lord.
My lord, it's a service tax matter.
Okay.
My lord.
That's respondent number 2, my lord. So, my lord.
Yeah. My lord, as was said, the pleadings in the first matter are completed. In the second matter, the impugned order relies only on the first impugned order. And we had filed this petition on 19th August 2024, the second petition.
Yes.
And since then, it has not come up. My learned friend was given time on the last occasion to file his affidavit. I leave it to my lords what time to give him, but if my lords could A, give us a date, B, continue the interim orders which are already there, the interim protection orders. And my lord, I was to request my lord that I could actually be there in person on 28th March before my lords, because 27th I have a hearing in Guwahati and I could then come and personally present the case before my lord.
Yes, what do you say? 28 March?
28th March, actually, my lord, I will be out of station for wife's treatment. So that's the problem. It will come on the first of per week to April or any date in April.
You wanted to file affidavit in the second matter.
My lord.
Okay, you
Which
appear for
one?
respondent 2 to 6.
Yes.
You're for respondent 2 to 6.
That's one number two, only two, my lord. That's one number two.
Respondent number 2.
Two, my lord.
In the second writ petition.
Yes, my lord. Second.
Which, my lord, on the last occasion also they took time on my lord's order of 12th of February 2025 to file this particular affidavit of theirs. They were asked to file by the 4th of March.
Well, actually, there's a delay in giving the parawise comment because the department have sought for some clarification from the ministry. That has been received. So yesterday there was an instruction, telephone instruction, they need 3 weeks time to file the affidavit.
So we'll give you a date. You file your affidavit by then.
My lord.
But definitely you'll have to file it. Yes, you were there for which case?
For the same, sir,
For the
petitioner.
case. You are assisting the.
Assisting.
Yes. Your good name, you are Mr. Rohan?
Rohan Shah, my lord.
Okay. You are assisting Mr. Rohan Shah?
Yes.
I heard Mr. Rohan Shah, Learned Senior Counsel, assisted by Mr.
K. Dangan.
K.
Dangan. DANGGEN.
Have you got it? Okay. K so and so. For the petitioners in both the writ petitions. Also had Mr.
M.K. Boro.
M.K. Boro, Learned Counsel, appearing for the respondent number
2, my lord.
2. In both the writ petitions.
Both the writ petitions, my lord.
Mr. Boro submits that he, although affidavit in opposition has been filed in WPC number 203 of 2024, he prays that further 3 weeks time may be granted in WPC number 342 of 2024, since he is yet to receive his instructions. Stop Mr. M. Kato, Learned GSGI, appears for respondent number 1 and 2.
1 only.
1, sorry. And what is your submission?
Basically, respondent number 2 is.
Are you going to file anything?
No, madam. Not required.
You'll not require.
Yes.
And submits that respondent number 1 is basically a pro forma respondent and will not be filing any counter affidavit. Stop considering the prayer made by Mr. M.K. Boro. For the, how much time? 3 weeks?
3 weeks.
3 weeks time is granted to file counter affidavit in WPC number 342 of 2024. The counter affidavit should be filed on or before.
My lord may give us a week after he files.
Okay. On or before. Second of April.
Very well.
2nd of April 2025.
Yes, ma'am.
With a copy to the other side. Upon filing of such affidavit, the petitioner will be at liberty to file a response within a period of 1 week. List this matter again. Before the vacation?
My lord.
Yes, my lord. And would my lords please give me a Friday if it is possible?
Sorry?
Would my lords please give me a Friday if it is possible for my lords?
Well, if possible, after vacation, my lord.
My lords, the first matter was filed in 2022, my lords. This has just been dragged on forever. It was in Guwahati, it has come here. We've had almost 10 weeks go in filing of affidavits. My lords will please list it pre the vacation, my lords.
Okay, Friday may not be practical.
Very well. I'll take whatever date my lord gives, and my lords will continue the interim release.
We have it on just before the vacation.
Very well.
on 10th of April.
Very well.
My lord, let it be on 11th April, my lord, because there are two heavy.
11th is not practical, that's why. Otherwise, you take a date after the vacation.
My lord, after vacation, my
No,
lord.
my lord, my learned friend is dispensing these dates as if we have all the time in the world. He has 2 dates are mentioned which don't suit him. Let him give a date. Is it 9th? Is it 8th? Is it 7th April? Let him give whatever date.
No, I'm saying any date after vacation, my lord. Because
My lord, we can't wait this long. It's a matter of service tax. It's an indirect tax. My lords, we are constantly harrying by this issue. My lords will hear it. It's a 2022 petition, the first one.
All right, 10th of April then.
Yeah, very well.
10th of April.
Great.
So supposing you don't complete, you can spill over the next day. Because Friday, it's a bit uncertain. Things are certain. So 10th of April will be fine.
And my lords will continue the interim relief orders.
Interim order passed earlier shall continue till the next date of listing.
I'm grateful to you.
Issue before your lordship is very simple, my lord. The petitioner was
Just a minute. Mr. Roy,
Lordship,
you were supposed to file an affidavit.
I have filed Lordship.
When?
My friend has got the copy, but it could not be filed because some technical issues were there, Lordship. Otherwise, I have given the copy, Lordship. My friend had received the copy, I think.
So both of you have the copy. Why not the court?
Lordship, I have sent it because of some.
My lord, in fact, on the last occasion, my lord, they were directed to my lord the file affidavit in advance, my lord.
You rectify and file it.
My lord, and only because of that reason, my lord, the matters are being delayed, my lord. The huge amount of my lord, the crores of rupees are being my lord, held by them, my lord.
If there's some defect, you rectify and file it.
Lordship, that by today it will be cleared, Lordship.
Then, my lord, in that case, my lord, may I pray the matter may be listed tomorrow, my lord, for my lord, the disposal, my lord. I am, my lord, the facing, my lord, the financial, my lord, the
We
difficulties.
list it on Monday, not tomorrow. Mr. S.S. Roy, Learned Counsel for the Power Department, submits that although the affidavit has been served to the learned counsels for the parties, but due to some defect, the affidavit could not be filed. Stop. He, however, undertakes to rectify the defect and file the same within this week.
Lordship.
List the matter again on Monday.
Lordship, let it be on 26th, Lordship, Wednesday.
My lord, 26 will be too long, my lord.
My lord, 24, I have some, Lordship, on 26, Lordship.
My lord, only because of their problem, my lord, I am, my lord, always, my lord, that is the barrier from the beginning, my lord. My lord, may I pray that, my lord, matter may be listed on, my lord, 24, my lord, Monday.
What problem do you have, Mr. Roy?
Lordship, I have some fixed matters, Lordship. I will not be able, Lordship.
Every time, my lord, only because of my friend.
Lordship, I understand, Lordship. On Monday, Wednesday, Lordship, I will...
Make it Tuesday then.
Tuesday, madam.
This is the matter on 25th.
Lordship, Wednesday, Lordship. Lordship,
Why?
let it be on Wednesday. I will try to come down there, Lordship. That's why, Lordship. On Wednesday, Lordship.
Every time afternoon, my lord, friend is appearing.
My friend
2
is
PM,
accommodating, my lord. My friend is accommodating, Lordship, on
then,
Wednesday.
in that case, 20, my lord, 20 of my lord, this month, my lord.
20, I will be, I will not be there, Lordship. I will be out of station, Lordship. 20 and 21, I will be out of station. 25, Lordship, Wednesday, Lordship.
25 is Tuesday.
Tuesday, man. 25.
26, sorry. 26, Lordship. 26 on Wednesday, Lordship.
Kato, you wait.
Waited.
Malad, I have no option. The council is taking time. Department is not making
the matter again on 26th
Lordship.
of March, as paid for by Mr. S.S. Roy.
Lordship.
Stop. The Learned Counsel also assures the court that he will appear physically on that day to conduct the case.
I will try, Lordship. I will.
You have to appear.
Lordship.
Yes.
All right.
Yes. Huh? Yes. Delay in filing GST.
$58.
You have a copy?
Yes.
No, read it. Sorry?
So at first 16.4, my lord, at first section 16.4 GST, my lord,
Hmm.
when the GST is not filed in time, they cannot claim the credit, in the credit. Now that for the recent amendment, my lord,
Hmm.
this has been extended, my lord.
Extended since that means that they can now claim. What is the challenge made here in the writ petition? The sheet. Notification as ultra vires the constitution, ultra vires the provisions of 168.
Yeah, we have made a provision 168 on this, but the matter primarily is related to 16.4 of the GST.
Relates to
These two matter.
which provision? No, which provision?
16.4. 16.4.
16.4.
The registered person cannot be entitled to tax credit in respect of any invoice or credit note for supply of goods or service or both after the 30th day of November, following the 10th of the financial year to which the invoice or debit note pertains or furnishing the relevant annual return whatsoever is earlier. So, in this case, the petitioner they okay filed the return by 20 October 2019.
16.4, which one are you reading? Section 16.4.
Yes, sir. Yes, yes.
16 subsection 4. Just a minute. I have not got the GST yet. A registered person shall not be entitled to take input tax credit. This is the one.
Yes.
In respect of invoice or debit note for supply of goods of so and so, following the end of financial year to which such invoice or pertain or debt note pertains, or furnishing of the relevant annual return, whichever is earlier. Now, what is the amendment?
16,
Hmm.
subsection 5.
Subsection 5 was inserted now.
Hmm.
The date has been extended to till 2021.
November 21.
Yes, madam, November 2021, madam. So they have filed it on 13 November 2019. So now they are eligible to madam.
Sorry?
They are eligible to claim the item.
They're eligible to claim in view of the amendment.
In view of the amendment.
No, the claim is made under which provision? Otherwise,
My lord,
claim is made under which provision?
16.4, my lord.
16.4. 16.4, previously, prior to the amendment, there was some some cutoff date.
Yes, it was on it was at 2010-2019.
How do you get the date?
But it is in the page number 42, my lord, of the writ petition. There's a demand note, my lord.
No, the act just provides certain time limit.
Yes, on the certain time limit, it says of the 30th day of November.
30th day of
November.
Of which year?
Of each financial year.
Okay, 30th day of November of each financial year. Now, this stands extended to
November 2021.
21, giving a particular year.
Yeah. No, my lord. All returns filed up to 2021, they are entitled from 17 onwards.
From 17 onwards.
Because, my lord, there's
Now-
initially, my lord, there in the filing, my lord, there's some technical issues are there because GST is a new concept. People are facing difficulty. To ease of doing business for that, the authorities are taking the steps.
Show me the impugn order. It's 22-4.
It's page number 53, my lord.
53. 53.
Yeah, it starts from 53, my lord.
This is annexure F.
Annexure
No, they are talking about particular order dated 22-4.
22-4, which annexure H, my lord. Page 54.
53.
Yeah, 54. Page 53.
Order in original.
My lord, very original, my lord.
What is this regarding? I confirm the demand of so and so, so and so.
Yes, sir.
Which demand has been confirmed?
The demand notice made in page 42, my lord.
42. 42.
Yes, my lord, page 42.
It's in a
In para 2, my lord,
Hmm.
page 42, annexure D.
42 is not annexure D.
Annexure
Something wrong with the pagination. Annexure D.
Annexure D. D.
Annexure D, yes.
Annexure
Where's annexure D? This is C.
D. 43.
44. Demand comes show cause notice.
Demand comes to cause.
That is page 44. Your pagination is 42.
Well, there are two paginations. One is light, one is dark. The Jalka one is 42, light one is 44. So para 2, my lord, it reflects that.
Yes.
The main issue, my lord.
Please read.
Whereas during verification of returns filed in the GST portal, it was observed that the said notice filed returns in form GSTR 3B in terms of section 39 of the said act for tax period from March 2019 after 2010-2019, that is on 13/11/2019, and availed and utilized input tax credit in electronic credit ledger maintained under section 49(2) of the said act. So they have filed after 20 cutoff date. That is on 13/11/2019 they have filed, and they have availed the input tax credit.
What they have availed?
In the input tax credit.
Input tax credit.
Credit, my lord.
Then,
My lord, in
so what has been demanded?
So what demanded, my lord?
What is demanded now?
In para 4, my lord, is done, my lord.
Whereas time limit.
Whereas time limit for availing input tax credit for the invoices issued during the financial year 18-19 was on 20/10/2019. But in the instant case, the said notice availed and utilized the input tax credit of rupees 1,88,24,200 only, which includes integrated tax of rupees 93,93,722 only, central tax of rupees 47,000.
In contravention of section 16(4)
16(4)
for the financial year 2018-19, correct?
Correct, my lord.
Then ultimately, what is the order?
Ultimately, my lord, the demand was raised, my lord.
Which paragraph? Show cause, this is a show cause.
This is a show cause.
There's no penalty as such in this. Just a show cause.
No penalty as such. These are show cause, and this is the final adjudication order.
Then after the show cause notice, where's the final order?
This is the page 53, my lord.
53?
Order in original, my lord.
53.
My lord.
53 is not an original.
There's an extra H, my lord, the previous.
An extra H, okay, 55. Then
here the amount of penalty is imposed.
I confirm the demand of interest. That means the show cause notice.
Show cause notice, my lord.
That notice has been confirmed.
That's confirmed. Okay. This order will be set aside, man, because on the strength of this amendment.
In the strength of the amendment, the show cause notice and the original orders in original will go.
Will go, man.
Correct.
Man.
Now, since it has been extended up till November of 2021.
2021.
Yes, your good name?
D. Riba.
Rema.
Yes.
Please write down her, Miss D. Rema, learned counsel for the petitioner, and Mr.
M.K. Boro.
M.K. Boro.
Standing counsel, CGST.
Standing counsel, CGST.
Central Goods and Service Tax.
And Mr. M. Kato, learned DSGI for respondent. One. So by filing this writ petition, the petitioner has challenged the demand cum show cause notice dated 21/11/2023, bracket annexure D, by which the petitioner has been asked to show cause as to why the amount of IGST, CGST, and SGST amounting in aggregate to rupees 1,88,2 24,200.00 availed and utilized during the period of March 2019 should not be demanded and recovered under section 73 bracket 1 of the CGST Act, is it?
PMGSY Act.
So although the petitioner replied to the show cause notice, the Assistant Commissioner, CGST, and what is this? CN.
CX, my lord.
CX, what is CX?
CX Customs, my lord.
CGST and CX Itanagar Division provide the impugn order dated 22/4/2024. Confirmed the demand notice and imposed penalty of rupees 18,82,420 on the petitioner in terms of section 73 bracket 9 read with section 122 bracket 2 bracket small a of CGST Act 2017. Aggrieved, the petitioner is before this court. Stop. Next para. The learned counsel for the petitioner submits that although entire input tax credit in respect of any invoice or debit note for supply of goods or services has to be made before the 30th day of November following the end of the financial year to which such invoice or debit note pertains to. But section 16 has been amended. Section 16 of the GST Act has been amended by the, what is this? Finance Act.
Finance Act.
Finance Act,
2024.
2024, which was published in the Gazette of India on 6/16 August 2024. By which the time prescribed has been extended to 30th day of November 2021. Stop such being the position, the petitioner is entitled to avail the benefit of the input tax credit So she therefore submits that the impugned demand cum show cause notice and the orders in original should be set aside. To stop, the learned counsel has also submitted that in a case of similar nature, a division bench court, white order dated 16/9/2024, passed in WPC number 470 of 2022, taking into account the amendment of section 16 of the CGST had set aside the order in original, which was challenged in that case. And the respondent authorities were directed to consider and pass appropriate order, taking into consideration subsection 5 within bracket, 5 is within bracket, of section 16 of the CGST Act 2017, White Amendment, to the Finance Act 2024, dated 16/8/2024. To stop, she therefore submits that a similar order may be passed in the instant case. Mr. Borough, learned counsel, standing counsel, fairly submits that in view of the amendment brought in by the Finance Act, the impugned show cause notice and the orders in original what will be
Yes, let me set aside number. And will be taken back, Bernard. If they go and
will have to be recalled.
recalled.
Mr. M. Kato, learned DSGI, submits that the respondent number 1 basically is a pro forma respondent and submits that although the respondent number 1 has nothing much to say in the matter, but in view of the amendment brought in by the Finance Act, the impugned show cause notice, demand cum show cause notice, and the order in original cannot be sustained. Next para, upon hearing the learned counsels for the rival parties and upon perusal of the materials available on record, and taking into account the amendment brought in by the Finance Act, as stated herein above, the demand cum show cause notice dated 21/11/2023 and the order in original dated 22/4/2024 are hereby set aside. Now, the respondent authorities are further directed to consider and pass appropriate order by taking into account the provisions of subsection 5 of section 16 of the CGST Act 2017 and the amendment to the Finance Act 2024. With the above observation direction, with petition stands disposed of.
Hello.
May I please, Your Lordship? Lordship, I'm appearing on behalf of Mr. Arish Nawam, Your Lordship, Advocate General, Additional Advocate General, Your Lordship. He is the conducting counsel, Your Lordship. He have instructed me to take an adjournment for today, Your Lordship.
18.
Yes, he is the leading counsel here. He is yes.
What is the reason? He was here in the morning.
He have some personal difficulty, Your Lordship.
No, my lord, actually this is several time occasions adjournment by the government side, whereas epidemics of the already ready for the admission hearings. Today again, the adjournment for actually, my lord, this is already government has filed the epidemic. This matter is only for the though only one is two issues is there. Epidemic only says that everything is smoothly conducted of the tender work. Only is that the one landowner was complaining that out of that the 27 landowner, except one single person is a complaint. Second point is the only for the interference of that the honorable MLAs verbally directed to the board plotting or cancellation of the tenders. Now third point is that the Department of the Rural Developments has smoothly conducted of that the plotting of tenders. There was no any objection. As per the epidemics file, we are ready for that.
No, what is the response here? Yeah, the tender has been cancelled.
Yeah, my lord, this tender has after the successful conduct of the tenders.
You are the successful bidder.
Yes, I am successful bidder, my lord.
After being successful, they have cancelled the tender.
Yes, my lord.
It has been retendered.
Not retenders. Again, without the retenders, the department has again says to the RD department is the my lord that is a nodal officer as per the government's directed to the RD is the government nodal officers, nodal department. Now, second is without any plotting of tenders, the again says to the DUDA, District Urban Development Officers, for direct recruitment of the Group B, Group 4 post, my lord. So that is I challenging this order of the cancellation orders. Even the learned deputy commissioners is the chairman of this tender. Now, without any obtain the proper from the government side, the directly endorsed to the DUDA department, district rural, district urban department for the direct recruitment, my lord. That is my challenging of the missed cases of filing, my lord.
What is this, a tender matter or a recruitment matter?
Floating of the tender. Actually, my lord, this is the Settigara film institutions for the recruitment of the manpower outsourcing for agency. It should be recruitment through the agency, but not directly by the department, my lord. According as per the direction of this Kshatriya Film Institute of the Calcutta, the instruction to the Arunachal Pradesh Film Institute, my lord, for the recruitment of the main outsourcing agency, my lord. So that the Department of the RD has, my lord, floating of tender for sourcing of that bidders. According that out of the 3 bidder was there, Now, my lord, I am a successful bidder.
No,
Now-
this is just a minute. This is a tender for what?
This is, my lord, this is a plotting of tender for the recruitment of that manpower.
Manpower,
Yes, outsourcing manpower.
outsourcing. So various agencies will take part.
My lord?
Various agencies will participate.
Yes, yes, my lord.
So they want the government, who's the floating, is by the project director?
My lord?
Rural development
Rural development, my lord.
wants to outsource
Yes, sir.
the manpower
Yes, my lord.
of various category for film and
Yeah, appointment of the.
television institute.
Yes, yes, my lord. Exactly.
So manpower,
Members, the employment, my lord.
employment.
Yeah, employment.
So
Like a group B, group D post, the is only for the billing system, the Parade billing system for the recruitments. The agency can be, agency only the deal with this, all these things, but not by government department. That the system is like this, my lord, that under the Ministry of India Broadcastings, the director to the Chettigaria, Film Institute of the Calcutta. Calcutta is the historic bodies, the own autonomous powers. As accordingly that the Calcutta, the again directed to the state governments for the recruitment of, my lord, the sourcing of main power outsourcing for the job agency. So according to plotting of tender was done are the department as per this government and endorsed to the nodal department.
anyway, see, since Mr. Nabam is not here and they want adjournment, what is to be done? We take a date.
Well, this is again and again adjournment, but everything is my record matter. Epidemic file, the London Deputy Commissioner is this respondent report is the main respondent, my lord. Is the Deputy Commissioner already filing? The RD also, Department of Rural Development is already filing. That's my lord, that epidemic is very clearly is that there is no any objections, except is that what the ground of the council was that one main landowner was the complainant. That how one man can complain that out of the 28. 27 landowners, whereas the state government has already recruitments in the year of 2016 for the establishment of the film institute at the Jota, my lord.
See, I'll give you a date. We'll list it on some date.
Your Lordship, kindly fix this matter on 20, Your Lordship. It has been-
20?
Yes, 20th of this month. Your Lordship. It was requested by the
20th of.
My lord, let me fix for tomorrow for disposal of case, my lord, that this is,
he may not be available. Your Lordship. He
so,
has some dif-
my lord, so many
difficulty.
lawyers there, government lawyers, anyone can appear, your justice is there so for the delivery of the justice, my lord. Because of this epidemic, it's already filing.
We'll have it on Tuesday. Ask him to come on Tuesday. 18th.
I have some difficulty.
You are for which party?
I'm for 1 to 3. Party department.
Party, what difficulty?
I will be out of session.
Out of station.
Yes. 20 would be nice.
We'll make an observation that no adjournment then.
Yes.
Fix on 20. Okay.
If not, Lordship.
Although the counsel for the petitioner has sought to impress upon the court that there is urgency in the matter and the case should be heard expeditiously. My prayer has been made on behalf of Mr. R.H. Nabam, learned additional AG, stating that he has some personal difficulties today to conduct the case and that the matter may be listed on 20th of March 2025. Stop considering the prayer so made on behalf of the learned additional AG. List this matter on 20th of March 2020, okay? 20th of March 2025. No further adjournment will be granted. Yes.
My lord, as per the last order, my lord has
Yes, my lord.
asked us to take instruction as to the clarification, how the earnest money is calculated, my lord. My lord will kindly see the last order. The learned counsel for the petitioner submits that as per CPW manual 2014, particularly at section 19.3, 2, for the works estimate to cost more than 10 crores, the rate of earnest to be deposited is rupees 20 lakhs plus 1% of the estimated cost in excess of rupees 10 crores. The learned counsel submits that considering the said provision, the amount stipulated in the NIT dated 3/2/2025 for non-APST contractors has to be more than 90 lakhs 63,000. In view of the above, so and so, notice was calculation was how the calculation is made. My lord, to this, my lord, we have instructions. My lord, it is very
please, Lordship. Lordship, the respondent authority, any clarification, let them come with the affidavit, my lord.
Okay, let him just explain.
Yes.
Yes.
In that event, we'll come with a proper affidavit also if required, but the interim order is there. That's why, my lord. My lord, will kindly say the relevant paragraph at the last page we have.
Last page.
Yes. This is the abstract of the CPWD manual. 5.1.2 rates of earnest money.
Yes.
Number one is for works estimated to cost up to 10 crores as notified from time to time 2% of the estimated cost. Meaning thereby from 10 crores first 2%. 2% that comes to 20 lakhs, my lord. 10 crores means 20 lakhs, my lord. Then second, my lord, this is relevant. For works estimated to cost more than 10 crores or as notified from time to time, here it says rupees 20 lakhs plus 1% of the estimated cost put to tender, 1% of the estimated cost put to tender in excess of that earlier 10 crores, my lord. Meaning thereby, after 10 crores, whatever is in excess, 1% will be calculated, my lord. For example, if it is a 100 crores project, up to 10 crores, the earnest money will be 2%, that means 20 lakhs. Thereafter, from 10 crores onwards, up to 100 crores, 1%. It may be 99 crores also, 1%, meaning thereby 20 lakhs plus another 1% will be 99 lakhs, my lord. So this calculation, my lord, in the second page has been given, my lord. The total amount is 77 crores 63 lakhs 85,000 so and so, my lord. Then for the first up to 10 crores, it is 2%. That comes to 20 lakhs, my lord. Then the remaining 67, which is in excess of the 20 lakhs, 10 crores, my lord. 67 lakhs, 63,000, 85,000, so and so. Then 1% is taken. That comes to 67 lakhs, 8,854. Now, therefore, the total is
this 67
is in the excess of 10 crores.
No, 6 crores 7 lakhs, 76 lakhs, isn't it?
This will be 67 crores 63 lakhs.
67 crores.
Yes, my lord. Total is 77 crore 63 lakhs. Total is 77 crores, my lord.
Okay.
77 crores 66 lakhs, something, my lord. Now for the first.
For works estimate up to cost up to 10 crores, 2%.
2%. Then for
works estimate cost more than 10 crores will be
20 lakhs is automatic.
20 lakhs is that 2% already?
Yes, already. Plus 1% of the estimated cost put to tender in excess of rupees 10 crore.
So plus 1% of the estimated cost.
Put to tender.
Put to tender.
In excess of 10 crores. 20 lakhs is 2%, which is already there, and 1%, which is in excess of that.
Okay.
Second page is more clear, my lord.
So in the present case, what was the amount arrived at?
In
My
the
lord,
present,
for non-APST, 90 lakh 63,000 as per tender dated 3/2/25
No, okay.
for general categories.
the estimated cost put to tender is 77 lakhs, total estimated is 63,800, 85,840. Now, second calculation, my lord.
The petition is aggrieved not with the earnest money, the quantum fixed for APST.
Yes.
But the quantum fixed for non-APST.
Yes, my lord.
You are an APST.
Yes. I
So they have given
believe
the
he
calculation.
cannot have any grievance on this.
See, the other day also, there was some sort of a what's that? Yes. Something was there, in fact, which perhaps
my lord, there is a notification.
We could not calculate at the time.
Yes.
But one thing court had noticed is that for works estimated to cost up to more than 10 crores, or as notified from time to time, 20 lakhs. That much is okay.
Yes.
It says plus 1%. That also is okay. 1% of the estimated cost put to tender.
In excess.
In excess
Set
of
that
rupees
10
10 crores.
Yes.
This part was there. So
Yes.
there was some thing which was noticed by this.
That's why, my lord.
And what exactly is the calculation
Yes.
has been brought up today.
Yes, my lord.
So if we go by that, what is wrong in this?
He cannot have any grievance also, my lord.
My lord, that's why my prayer is that, my lord, if they have clarification on based on the calculation being made by the department authorities, so let them, my lord, come.
They
with
will file affidavit,
short date may be given.
but the interim order will go.
Yes,
Yes, my lord, short date may be given now for next Monday.
You can take any date, but interim will go.
Yes, ma'am. Because it's a developmental work.
Yes.
My lord.
Is right.
Whatsoever calculation, my lord, they are submitting before this honorable court, so that copy has to be furnished with the affidavit, my lord.
We'll
Yes,
direct them to
I
file
have
affidavit.
given him a copy.
They will
also.
file affidavit if
Yes.
they want to. He'll give you
I've given a copy of this also.
yes.
Yes.
Furnished.
You want affidavit out of
My lord,
this?
let them come with the affidavit, my lord, for the record of this honorable court also.
Now, who are the parties here? Any private parties here?
No, my lord, only government has come.
Okay, parties are represented by the respective councils. We'll stop. On 3/3/2025, court passed the following order. Please abstract it. Next para. Today, Mr. N. Ratan, on additional advocate general, submits that he has received instructions in the matter. And submits that the as per clause 5.1.2 of the CPWD manual 2024, which is regarding rates of earnest money, the calculation has been made by the respondent authorities in terms of clause within bracket 2 of the said provision, which provides that the earnest money for works estimated to cost more than rupees 10 crores or as notified from time to time, the rates would be rupees 20 lakhs plus 1% of the estimated cost put to tender in excess of rupees 10 crores. So he submits that in the instant case, the estimated cost is rupees 77,63,85,840. And as per clause 5.1.2 bracket 1 of the CPWD manual, 2% of the estimated cost
up to 10 crores.
up to 10 crores would be 20 lakhs. And 1% of the estimated cost put to tender in excess of rupees 10 crores can be calculated as rupees 67,63,85,840. Stop. Accordingly, the earnest money to be deposited by non-APST contractors is arrived at rupees 90,63,000. Stop. As such, the learned additional AG submits that the petitioner, who is otherwise an APST contractor, cannot have any grievance with the said fixation. Stop. Considering the above submission, the learned additional AG shall file an affidavit incorporating the instructions he has received. Stop. This court being prima facie satisfied that the calculation has been made in terms of the relevant provisions of the CPWD Manual 2024, is not inclined to extend the interim order passed earlier.
Till filing of affidavit, my lord.
No.
My lord, even in their calculation also, 858
Rounded off.
rupees is less, my lord. So
And
even
this-
1 rupee calculation is required, my lord.
Will not go
Even-
by all those decimal points and 1 rupee, 2 rupee thing.
Yes, ma'am.
Please this matter again after 2 weeks.
Obliged.
Till filing of their
My lord,
affidavit, my lord.
no,
That's
developmental
next month, my lord.
works, my lord.
My lord, in their clarification also not satisfied, my lord. Even less of.
You're not
850.
satisfied. What is satisfied? What to do? I've seen it, so I don't think there's any cause for any extension.
Obliged, my lord. In item 24, we were supposed to get latest instruction, whether the high power committee for pay anomalies have taken any decision on, with regard to the petitioners, my lord. My lord, our latest instruction is that in this month of March, since the members of the high power committee we are busy, so they will be sitting in the month of April only. So I pray, my lord, can this be taken up in the last part of April so that after
March.
It's a high powered committee or high level standing committee?
High level
High
is
level.
the standing committee for pay, considering pay anomalies.
When are they sitting? April?
In the month of April, my lord. This month they couldn't sit, my lord, because
April,
of
which time?
April, that fixed time has not been given, but can this be fixed in the last part of April so that after the sitting?
No. First week of April.
These high level standing committee, they are commissioners and secretaries from different departments, my lord. That's why.
Let them sit.
Yes, ma'am.
See, since this matter relates to pay anomaly,
Yes.
experts are required to give their inputs. Because court's interference in such matters is quite, you see, since the court is not equipped with all the expertise. So unless some recommendation comes from them, it will be difficult to take a call.
Why not in almost all the department they have completed their work and they're getting the salary also as per the latest 7 pay commission. Now it is coming under 8 pay commission. We are lacking behind it.
You'll get your due share, whether time has flown or not. So anyway, we'll have it on 22nd. Just after reopening.
Yes, madam.
22nd of April.
As a last chance, then.
My lord,
As last chance.
sitting of the, because it's it will depend on the sitting, my lord. Otherwise, if we go legally, my lord.
Mr. N. Ratan, Learned Additional Advocate General, submits that the high-level standing committee on pay anomaly is due to sit only in the month of April 2025, and therefore prays that the instant matter may be posted in the last week of April 2025. So Mr. T. Son, Learned Counsel for the petitioners, submits that the petitioners have been waiting for consideration of their pay for a long time now, and therefore there is urgency in the matter. Considering the above submissions, let this matter be listed again on 22nd of April 2025. Mr. N. Ratan, Learned Additional Advocate General, shall apprise the court about the
latest development,
latest status of the
High-level committee report.
Report to be submitted by the high-level standing committee on pay anomaly.
All right.
Your Lordship, I'm for respondent number 6.
Yes.
Your Lordship, 3 weeks time may be given to file a reply.
None appears for the petitioner when the matter is called. As paid for by the Learned Counsel for respondent number 6. Further 3 weeks time is granted for filing counter affidavit. Yes.
I also need some time to file affidavit.
Likewise, 3 weeks time is granted to the state respondents for filing counter affidavit.
Wait. When this is my lord, respondent number 5 has filed an affidavit, but the director of housing and the my lord RWD has to file the affidavit. Pertains to a dispute pertaining to my lord allotment of water, government activities.
Allotment of water.
Yes.
Dispute between two private parties. For what?
The dispute is with the government, my lord.
Who has been allotted?
I was initially allotted.
And it was cancelled.
It was cancelled and allotted to somebody else. The private respondent has not appeared. But what they are saying is
I was allotted by the director housing, but they are saying the quarter is of the RWD pool. Now the RWD will also have to clarify that.
Quarter is of the,
RWD pool, comes under the RWD pool, that's what they are saying.
okay, where do they say that? In their affidavit?
No, they have not filed the affidavit. It is there in the, it's an order passed by the page 44 by the estate officer. Now in my humble opinion, he didn't have to do any jurisdiction.
The respondent number 5 has filed, your lordship. ADC, your lordship.
Five has filed. Now he has absolutely no jurisdiction in passing the order.
Five.
But, yeah.
Who's five?
ADC, your lordship. Come estate officer.
So this is the order passed by the ADC.
Yes.
How do you say that he has no jurisdiction? ADC is acting as a estate officer also.
Yes.
Yes.
But they could be in respect of unauthorized occupants. I was on the basis of a allotment order. In any case, my lord, RWD will have to clarify and the housing has to clarify which pool it comes. If it really is under the RWD pool.
The estate officer's jurisdiction is limited to unauthorized occupants, not regarding allotment.
In my humble understanding, yes.
And you are from which department? You are an employee of?
MTS, man.
Sorry?
MTS, multitasking staff.
You're from in which department?
Under civil secretariat, your lordship. So working under.
Civil secretariat. And who would be the allotting department? Who will be the competent?
The housing department. And it was the housing department that allotted me the quarter.
Housing department.
Since this quarter belongs to RWD pool, your lordship. So chief engineer RWD, your lordship, is the allotting authority, your lordship.
RWD has not filed anything.
No.
That is why I have been trying to submit. That's the understanding. That submission will have to come from the RWD.
Will.
Are they a party here?
Yes, your lordship.
Who's presenting?
Mr. Jimmy in the morning. He said he had no instructions. He's not here now.
Please write down challenge made in this writ petition is with regard to the order passed by the additional deputy commissioner cum estate officer Itanagar Capital Complex on 13/2/2024. Directing the petitioner. Holding the petitioner holding the petitioner to be allotted the government quota unauthorizedly and illegally, and further directing him or her to vacate the quota. Mr. D. Pangin, learned counsel for the petitioner, submits that a response from the RWD, the RW Rural Works Department. Rural Works Department would be necessary.
As well as the housing department.
And also from the housing department. Since the quota concerned is said to be
Falls under the RWD pool.
said to be falling under the, you said pool, what do you call that?
They said they have used the word pool, well, I'm not sure. Our understanding was that every house, even the High Court employees, there are allotted quarters, are issued by the housing department. That was my understanding. Now they will have to say this on some basis, madam. If they can show it in where.
What did I say last? Since Mr. So-and-so, learned counsel. Mr. So-and-so, learned counsel for the petitioner. From there you start. Said to be
There is the word they have used the page 45,
Where is that?
last paragraph. In view of the above, sir, I am of the opinion that since the waste belongs to RWD pool.
Said to be belonging to the RWD pool. Stop. Then no one has filed the affidavit.
No.
Respondent five only.
Oh, five
has
has filed, okay.
Yes.
I have the estate also.
For 2 and 3, your lordship.
Considering the same, the respondent. You appear for Ms. Basar, you appear for whom?
1 to 5, one to 5, your lordship. 1, 2, 3, and 5. For 2 and 3, your lordship will file the affidavit.
The respondent RW department and the urban development and housing department to file their respective counter affidavit. And for which, how much time?
For RWD, your lordship, standing counsel is there, your lordship.
I'm talking about the. how
For
much
2
time?
and 3, 3 weeks, your lordship. For house.
3 weeks time is granted.
Lordship.
All right. Interim order is there? What is the interim order?
The order was suspended.
And you are still in occupation of the
Yes.
quota?
Yes.
Okay. List the matter again after 3 weeks. Interim order passed earlier shall continue till the next date of listing.
Over.
Okay.
May I please, Lordship.
Yes.
Lordship, we have filed Wakalat Nama today for respondent number 4, 7, and 8 for NHPC. 4, 7, and 8.
NHPC.
Yes, your Lordship.
So you want some time?
Yes, Lordship. We will need some time to file our affidavit.
Your good name?
E. Payeng.
Mr. E. Payeng, Learned Counsel, submits that he has filed his power to appear on behalf of respondent numbers 4, 7, and 8 today. And prays that he may be given how much time?
4 weeks.
4 weeks time to file counter affidavit. Anyone else? Praying for time?
Yes, my lord, in fact, my lord, I'm not furnished with the extra copies, my lord. That is why I could not sit at this.
You are for which respondent?
For my lord, 5 and 6, my lord.
Mr. Mao,
Yes, we will serve.
the petitioners to serve requested extra copies to Mr. D. Kambu, Learned Counsel, for respondent number
5 and 6.
5 and 6 within 2 working days. List the matter again after 4 weeks.
Obliged, my lord.
Obliged.
Yeah.
Extra copies.
Extra copy idea.
May I please, your lordship.
Sorry, we'll start it by tomorrow.
Lordship, we have not been received extra copies, your lordship.
Okay. Ms. P. Sangeeta, Learned Government Advocate, submits that she has not received extra copies of the writ petition, and for which reason she could not obtain instructions. Stop petitioner to serve visit extra copies of the writ petition to the Learned Government Advocate within 2 working days.
Okay.
List the matter again after 3 weeks.
I provided from 3.
Any affidavit you filed?
No, I require 3 weeks time.
List the matter again after 3 weeks as paid for. Meantime, the respondents, including the respondent number
3.
3, represented by Mr. B. Picha shall file the counter affidavit.
There's an interim order, my lord.
Interim order passed earlier shall continue till the next date of listing.
Of nice.
Consumer name, no more. Names will have party names in the fund.
This is that hearing matter, my lord, the last occasion.
What is this?
Regarding, my lord, non-payment of, non-grant of non-practicing allowance. As far with those doctors who retired after 1/1/2024.
What was the cutoff date otherwise?
But there no cutoff date was there. The government has fixed the cutoff date, but in our humble submission, that is arbitrary.
Hmm.
Cutoff date, they have fixed 1/1/2023.
Hmm. So, can we have this matter some other day? If there is no such urgency.
In that case, let it be after 3 weeks.
3 weeks. Before the vacation or after the vacation?
After that.
Okay, let's wait for the parties, list this matter. For hearing. Any date you want or
No.
after the ensuing? What is this vacation? Is it summer?
It's a Bihu break.
After the ensuing Bihu vacation.
Oh,